Hello, I'm Ashley Strauss-Martin, General Counsel for the Realtors Association of New Mexico, and I'm here today to talk about two new laws that will impact broker that take effect July 1st, 2013. The first is a brand new law called the Homeowners Association Act, and as the title suggests, it deals specifically with how homeowners associations are governed and requirements of homeowners associations. The second is an amendment to the existing law, the Public Improvement District Act, and it has specific seller disclosure requirements that will have a great impact on sellers and sellers' brokers. The second law that takes effect July 1st, 2013 are amendments to the Public Improvement District Act. We are all familiar with HOAs, however many of you may not be as familiar with PIDs. There are thousands of properties in New Mexico that are located in PIDs. It's important that you familiarize yourself with PIDs in your area. To do so, I would contact your local government body, county and city, to find out if they have authorized any PIDs in your area. The amendments I will discuss will have a significant impact on listing brokers and sellers. So what is a PID? A public improvement district is a means of financing the construction or improvement of a local public improvements, such as streets, parks, sewer lines, drainage ways, and recreational facilities. A PID may issue special levy bonds or general obligation bonds to pay for the improvements or maintenance. The debt service on the bonds, interest, principal, etc., is charged to the property owners within the district in the same manner as are their property taxes. The Public Improvement District Act covers the formation of PIDs. A PID may be formed upon application submitted to the county or municipality in which the PID will be located, also called the governing body, along with a petition signed by the owners of at least 25% of the real property proposed to be included in the PID. The Act sets forth the specific requirements of the application. The governing body may then adopt a resolution declaring its intention to form a PID. The Act sets forth the requirements of the resolution. The resolution will direct that a hearing on the formation of the PID be scheduled. After the hearing, the governing body determines whether the PID should be formed based on the interest, convenience, or necessity of the owners, residents of the PID, and the citizens of the municipality or the county in which the proposed PID would be located. If the governing body determines that a PID should be formed, it will adopt a resolution ordering that the PID be formed and that an election be held on the question of whether to form the PID. A formation election includes the owners of the real property located in the PID and the resident qualified electors, who are the people who reside within the boundaries of the PID and who are qualified to vote in the general elections held in the state. The PID is governed either by a PID board comprised of the members of the governing body or by a board of 5 directors initially appointed by the governing body. Before constructing any public infrastructure improvement, the PID board must approve a study of the feasibility and benefits of the project proposed. The elements of the study are dictated by the Act. Prior to the approval of a project, the PID board must provide notice and opportunity to comment to the owners and the governing body and hold a public hearing on the study. If the report is approved, the PID board will adopt a resolution approving the project, identifying the areas benefited, the expected method of financing, and an appropriate system of providing revenues to operate and maintain the project. In order to provide money for any project purpose consistent with the general plan, the PID board may call for an election to approve a general obligation bond and/or for a hearing to determine whether a special levy should be imposed. General obligation bonds issued by the governing body are secured by the pledge of the governing body's ad valorem taxing power. The owners and the resident qualified electors must vote to authorize the PID to issue general obligation bonds and a levy of property tax to pay the debt service on the bonds. The PID board may also hold hearings to determine whether special levies should be imposed and special levy bonds issued. A special levy is a charge imposed against a property in a particular locality because that property receives a special benefit by virtue of some public improvement, separate and apart from the general benefits occurring to the public at large. For example, if a special levy bond is issued to pay for a road improvement on a certain street, only the homes and other buildings on that street will pay the special levy. For both general obligation and special levy bonds, the PID board is responsible for imposing and causing the levy to be collected annually on all property within the PID that is subject to the levy to satisfy the debt service on the bonds, at the same time in the same manner as property taxes are levied and collected. A PID's levy constitutes a lien on all taxable property within the PID subject to the levy and may be foreclosed in the same manner as other property tax liens under the laws of the states. Liens will include delinquencies and interest. Also, when owners of property located within a PID fail to pay their taxes as required, the PID board may increase the levy or rate for the remaining property owners within the PID to meet the debt obligation. Most importantly for brokers is the requirement that sellers provide certain disclosures prior to the seller accepting an offer. Effective July 1st, 2013, prior to a seller whose lot is located within a PID being able to accept an offer to purchase, the seller, seller's agent, or seller's broker must provide the potential buyer a written notice of the following: information that the property is located within a PID, the purpose of the PID, an explanation that the purchaser is obligated to pay any property tax or special levy that is imposed by the PID board, an explanation that the property tax or special levy imposed by the PID board is in addition to other state, county, or local government taxes and assessments, information that the failure to pay the property tax or special levy could result in the foreclosure of the property, information that more information concerning the rate of the property tax or the amount of the assessment and the due dates of each may be obtained from the governing body, and information that a feasibility study was completed as part of the formation of the PID and that the feasibility study is available through the governing body. In addition, if the PID has issued bonds, the seller, seller's agent, or seller's broker must provide the following information. For special levy bonds, if a special levy has not been authorized by the PID board, information that a special levy has not been authorized, or if a special levy has been authorized by the PID board, the maximum special levy that is authorized to be imposed upon the property in the PID, or that the special levy to be imposed on the property in the PID has been prepaid in full as provided in the rate or method of apportionment. For general obligation bonds, if general obligation bonds have not been issued, information that the general obligation bonds have not been issued, or if the general obligation bonds have been issued, the amount of general obligation bonds that are outstanding, the amount of annual debt service on outstanding general obligation bonds, that the maximum rate and amount of property taxes that may be imposed upon the property in the PID are limited only by the amount of debt outstanding, and that the estimated or projected annual mill levy or special levy per $1,000 of assessed value as of the date of the disclosure, with an explanation that the estimated levy or rate may be increased by the PID board when necessary to meet debt obligations. There is no explicit provision in the Act that allows a potential purchaser to waive receipt of these disclosures prior to the seller accepting the offer. So where do you locate information about the PID? All PIDs are required to file and record with the county clerk the resolution ordering formation of the PID, the general plan of the PID, and the canvass of any general obligation bond election. In addition, PIDs formed after December 31st, 2013 must file and record within 30 days before June 1st and December 1st of each year the contact information for the PID board and the required seller disclosure information we just discussed. However, sellers are required to disclose the information we just discussed regardless of when the PID was formed. Because PIDs formed prior to December 31st, 2013 are not required to file with the county clerk's office the seller's required disclosure information, for those properties, sellers will likely have to obtain the seller required disclosure information directly from the PID and/or the governing body. In the event of a finalized sale, a buyer who suffers any loss of money or property, real or personal, as a result of a violation of a seller or seller's agent or broker not providing this information before accepting an offer to purchase, may bring an action to recover actual damages and may be granted injunctive relief under the principles of equity and on terms that the court considers reasonable. For example, rescission of the contract. The buyer may also recover attorney fees if he or she prevails. The seller's disclosure requirements do not apply to the transfer of property under a court order or foreclosure sale, the transfer of property by a trustee in bankruptcy, the transfer of property to a mortgagee by a mortgagor or successor in interest, or to a beneficiary of a deed of trust by a trustor or successor in interest. The transfer of property by a mortgagee or a beneficiary under a deed of trust who has acquired the land at a sale conducted under a power of sale, under a deed of trust, or sale under a court-ordered foreclosure, or has acquired the land by deed in lieu of foreclosure. The transfer of property by a fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. The transfer of property from one co-owner to another co-owner of an undivided interest in the real property, or the transfer of only a mineral interest or leasehold interest. For additional information on PIDs in general and/or a specific PID, parties should consult with the specific PID, if applicable, the governing body in which the property is located, and an attorney. Random has created a PID information sheet and a PID disclosure form. These forms will be available in zip forms and Instinet by July 1st, 2013. If you have any questions about this form, please contact the Random Legal Hotline at 877-699-7266 or in Albuquerque 821-1583, or email us at this legalhotline@nmrealtor.com.